previous videos, we talked about clause 18 of PAM contract. We established that the contractor is liable and should indemnify the employer against any damage or losses due to personal injury or death, losses or damage of the property. It was also mentioned that these indemnities should not be defeated or reduced, even though there are negligence of the employer, architect, consultant, and other authorized representative in failing to supervise or control the work of the contractor that result in personal injury or death, as well as the loss and damage to the property. Since it involved the indemnity to the employer, we discussed about the insurance that may be involved in a construction project. There are a series of the insurance to be prepared by the contractor, while there is another series of the insurance to be prepared by the employer. This shall help us to establish basic understanding before we proceed with our discussions in clause 19 that we will cover in these videos. Clause 19 is about the insurance. You may refer to the full statements from the PAM contract 2018. There are 5 sub-clauses here. The statements are lengthy. For a more precise understanding for the statements, you are recommended to read between the lines of each statement. I summarize the information in one slide here, and let us look into those. Clause 19 is about the insurance against the injuries to the person, as well as the loss and damage of the property. As you know, the construction work, in the case of any negligence, this may lead to damage of the property as well as injuries to the person. This kind of incidents normally is not wanted by any of the party. The contractor will need to carry out the work carefully. However, sometimes it happens. In the case this happens, at least there are insurance to cover those, to compensate the losses to the parties involved. So, the contractor to insure against the injury of the person as well as the loss and damage of the property. Before the commencement of the work, contractor will need to have insurance. And this insurance should have joint name of employer, contractor, subcontractor, and relevant parties. The insurance should cover for personal injury or death, as well as the loss and damage of the property. This also includes those caused by negligence, omissions, default, or the breach of the contract by any parties. This means that when any of this happen, either personal injury or death or loss and damage of the property, regardless whether it is due to the negligence of any of those parties, the insurance will still need to pay. The insurance is not relief from the liability, even though there are negligence due to any of those parties, leading to personal injuries of death as well as the loss and damage of the property. Now, this insurance should cover for the third-party liability. What does it mean by this third-party liability? For your information, we have the first party, second party, and third party under the definitions of insurance policy. The first party, it will be the insured party, which in this case, it will be the contractor. This is because before the commencement of the work, the contractor will need to have the insurance. The contractor is taking the initiative to have this to be insured. The second party, it will be the insurance company. The insurance policy is between the first party and the second party. The contractors finds an insurance company to insure for any accidents happen. The third party here, it will be another person who claims. Whoever suffer the loss due to those accidents shall be entitled to claim for the loss, and this will be the third party liability. In terms of the amount of insurance to be covered, it is normally stated in the appendix of the contract document. Now let us look at the details of the insurance policy. The insurance policy should include the following endorsement. First, there will be cross liability insuring the employer, contractors, and other related parties. The third party here shall include the architect, consultant, and their employee and representative, site staff, employee, and representative of the employer. The insurance should waive all the rights of subrogations or recovery against the contractor. That means when any of this happen, the third party now is claiming from the insurance company. And even due to the negligence of the contractor, after paying to the third party by the insurance company, the insurance company cannot claim from the contractor for whichever loss experienced by the insurance company due to the claim of the third party. In other words, the contractor is transferring his risk to the insurance company, and the risk will be fully backed by the insurance company. There is a term here called cross liability. The meaning of cross liability is given here. You see now this insurance is under the name of employer, contractor, subcontractor, and other relevant parties. There are more than one party being insured under the same insurance policy. In the case any accidents happen, the party at loss shall be entitled to sue the other party for the injuries or damage, and the relevant compensations will need to be given by the insurance company, as the risk has already been transferred from the insured party to the insurance company. Since it is the joint name, the insured party will be the employer, contractor, subcontractor, and other relevant parties. And any of these parties can claim against each other in the case of any accident. Once the claim takes place, the third party, it will be the person making the claim. The first party, it will be the party that the claim is against with. Now this party will be treated as the only insured party, and the third party shall be entitled to whichever compensations as stated in the insurance policy. To make the thing simple, let's say under the construction project, accident happens due to the negligence of the contractor. The damage is with the employer, so employer has the right to claim against the contractor. Now the employer will be the third party, and the contractor will be the first party. Since the employer is claiming against the contractor, and now the first party, it will be the contractor, and the contractor has transferred his liability to the insurance company, the compensations will need to come from the insurance company, paid to the employer, and the insurance company has no rights to recover anything from the contractor, even though it is due to the negligence of the contractor. Now let us look at another scenario. We have a joint name between the employer, contractor, subcontractors and others. Now it is the negligence of the employer which result in the accidents to happen. The damage will be onto the contractor. So the contractor has a right to claim against the employer. In this case, the employer should be the person insured and the contractor will be the third party. Whichever being claimed to the employer shall be paid by the insurance company as the liability has been transferred to the insurance company. In another word, the role between the first party and the third party can be interchanged under the principles of cross liability. This insurance policy shall subjected to automatic extensions or renewal until the certificate of making good defect. This is important. First, you need to know that this insurance policy should be valid until the certificate of making good defects. It is until all the making good works are completed that there won't be any activities of the constructions or work to be given by the contractor. Accident can happen at any time since the commencement of the work until completion of rectifications works. Therefore, the insurance will need to cover until to the end of the completions of the work. That's why it should go until the certificate of making good defects. Now, in the case that the project has been extended, probably because of the delay or some other reasons, the coverage of the insurance should also be extended as a result of the extensions of the project. The extensions of the project will put forward of this defect liability period, and the schedules of defect may be submitted within 14 days of the end of this defect liability period. Only with the schedules of defect, the contractor will need to do the rectification work. It is until all the rectification works are done, the certificate of making good defects are issued, and this ends the validity of insurance policy. These are about the principles of the insurance. This slide gives you an idea what are the insurance involved. We have SOCSO, Employee Social Security Scheme for local workmen. Theoretically, the contractor should register all the local workmen under the SOCSO. This also applies to all the subcontractor, and the contractor will need to pay all the necessary contributions to ensure all the local workmen are covered under this SOCSO. In the case that these local workmen are not being covered under SOCSO, there should be insurance for those workmen as an alternative to this SOCSO. Also, there are foreign workers who are not under the SOCSO. There should also be the insurance to cover the foreign worker. As long as the worker is working under this project, PAM contract will ensure that everyone will need to be covered by at least one of the insurance. It is either under the SOCSO or under insurance for the local workmen or under the insurance for the foreign workers. The contractor will need to take out and maintain and ensure the subcontractor to do the same to have those insurance covered for the workmen not subjected to the SOCSO as well as for the foreign workers. This needs to be done before the commencement of the work. there will be joint names of the employer and the contractor. And this insurance should cover all the liabilities, including the common law liability. And the validity period, it should be up to the completion date plus defect liability period plus 3 months. Normally the defect liability period is about 12 months. That means it is to be valid up to the completion date plus 15 months. If there is any delay in terms of the completions or any delay in terms of the making goods of the defects, this insurance should be extended or renewed at least 1 month earlier before the expiry. The purpose here is to ensure the respective workers are actually being insured and not being forgotten in the case of the delay of the completions. Clause 19 also requires that the insurance should be placed with the licensed insurance company, and it requires the approval of the employer. That means both the contractors and the employer should know and agree on which insurance company are undertaking this project. The contractor will need to pay for the insurance premium, and the receipt and the insurance policy should be provided to the employer, architect, and consultant. Everyone should know about this insurance. Everyone has the right to ensure they are insured, and everyone should also know about the policy of this insurance.